All please rise. The Fourth Circuit Court of Laconia is now in session. The Honorable Judge James Carroll presiding.
Morning. You may be seated. Welcome. Thanks for accommodating the court. All right, the court has reviewed all of the materials presented to it, and Mr. Sisti, it's your motion, and I'll hear from you in terms of what you need to have to say.
Thank you. Actually, Mr. Baer will address some of the legal points, and then I have a few comments that I'd like to
Sure.
make.
Just going to the scope, essentially we have 5 arguments, 3 of which go toward the disruption complaints and 2 of which go toward the lawful order complaints. But everything has a common ground, and that's that under a penumbra approach to the law, as far as Part 1, Article 8, Part 1, Article 22, First and 14th Amendments are concerned.
I'm glad you use that word penumbra, because I use it each week with my college students, and I'm glad somebody else is sharing that word.
It's certainly the best way to describe it, because this falls in the middle of a few different types of law. And as you can see from the cases, a lot of them have to do with hard protests against the Seabrook nuclear power plant. This was certainly not that, but shares elements of that, shares elements of the cases out in Chicago and New York, protesting politicians and things like that. But the idea is that there is a reasonableness factor that's clear through the law that requires, I guess, what you can consider a step-down approach. And the state is making the argument that because Mr. Baer said certain magical words, that being, that have to be arrested, or you're going to have to arrest me, that automatically creates a situation where arrest is appropriate. But the law says otherwise. The police have to try to make reasonable efforts to avoid arresting. They certainly shouldn't arrest because a person tells them to. There's no authority for that. But essentially, this is a situation where we have to look into the Constitution and act on first principles instead of making it just a matter of strict statutory construction and using judgment as to what was or was not required before things resulted in what might be considered a technical violation of the statute. And then I guess Mark can address everything else from there.
Your Honor has before him right now the actual video that they're relying on. You have the depositions that we're relying on, but let me kind of put this in some perspective. What we're dealing with here is a constitutionally protected right of speech, and what's even more interesting in this case, and what is much more powerful, is that it's a public meeting. It's a public meeting for the purpose of discourse, and it's the public meeting that really focuses our attention on what the problem is here. And I only say this because Your Honor runs public meetings every day in this courtroom. I've had the opportunity over the last decade to run public meetings as a moderator in Gilmanton, and it is expected at times that people are going to become emotional, and people are going to become upset, and people are going to voice certain things during the course of courtroom proceedings, during the course of public meetings in town. This is expected. This is what we expect. Now, do we appreciate it? Do we like it? Do we think that's just wonderful? No. But the response shouldn't be that we alone determine whether it's a crime at that point in time. There are certain responsibilities, especially when you're dealing with free speech, that we have to, as we've just already cited, step down the situation, try to deal with the situation. In this court, and I've seen it, and you've done it. You've had to warn people in here to relax, and you would give them what the result would be if they didn't relax. And that's, I guess, what we're kind of driving at right here. If it was up to me as a town moderator to kick people out every time I didn't like what they were saying, that's a problem, especially when you're dealing with public discourse, especially when you're dealing with the subject at hand. Mr. Baer wasn't talking about something off topic. Mr. Baer, in any expression that he was making during the course of this entire exchange, was on point. In fact, he was addressing the problem that he, in fact, told the folks over at the school board he was going to be there to address. He told the principal he was going to be there addressing it. There's no secret as to what he was going to be addressing. And quite frankly, the meeting started with an agenda, and you can check the deposition. The meeting started with an agenda, ended with an agenda. Each and every topic on the agenda was covered. That meeting in Guilford completed by hitting each and every point that the school board wanted to hit that night. Now, if you look at the cases that we rely on, and even if you look at some of the history of, another Guilford case that took place years ago, Mr. Hoffman, that wasn't the case. There was an exact purpose on the part of individuals to disrupt the meeting. That wasn't at all what Mr. Baer's intent was. His intent was addressed with the principal that day. And if you see the deposition, the principal and him basically came to an understanding during the course of the afternoon. And in fact, even after all the dust settles in this case, the school board agreed with Mr. Baer with regard to his concerns concerning the policy over at the school, and changed their policy based on his concerns. Now, I don't think it gets any better than that. I mean, he was focusing on a problem, he addressed the problem, they corrected the problem. That's not disrupting. That's exactly what those meetings are for. That's exactly why that meeting was called. Not not to have him vent, but to have something constructive take place during the course of the meeting. And it did. What was wrong, and what we have a problem with, is a unilateral dismissal of Mr. Baer from that particular meeting. Not just a dismissal, but the effectuation of an arrest, a crime for speaking out. And it's not a crime to speak out, and especially isn't a crime to speak out during the course of a public meeting like that. What you're going to see when this thing really distills down into a few things is that, one, nobody verbalized the complaint to Ms. Allen during the course of that exchange. Not one citizen verbalized a complaint stating that Mr. Baer was disruptive or keeping them from expressing what they wanted to express. You will see that he was speaking on point during the course of the meeting. You will see that any disruption that took place within the realm of about a 30-second period of time, which is, I have to say, just from experience, I've had to deal with things that went on for minutes at our own town meetings. People didn't get arrested for it. No alternatives were suggested to Mr. Baer. In other words, he wasn't told, just very frankly, if you continue to do this, you will be thrown out of the meeting or you will be arrested. The police didn't tell him that. Sue Allen didn't tell him that. There was some nonverbal wink or nod or something that went on where he didn't get ample warning as to what the consequences would be. It was a public meeting. All the expressions had to do with the subject at the time. And when he was escorted out, I tell you, this actually speaks volumes. When he was escorted out of the meeting, he was not resisting. When he was escorted out of the meeting, he was compliant, which also tells you something. If he wanted to be disruptive, if his entire thrust for being there was to be disruptive, he wasn't disruptive. He left the meeting. He didn't resist. He didn't assault the police officer. In fact, he asked, "What am I being arrested for?" Which was, I would say, a very valid question, since he wasn't disturbing anybody and since he wasn't disorderly. So I guess what I'm asking the court to do is to eliminate the ability of the individual that runs a meeting, whether it be a public meeting, whether it be something in the public sphere, from arbitrarily cutting off public debate in a public forum. I know it sounds simple, it sounds obvious, but you actually get to see it happened on the video that you have before you. And you have 4 depositions before you. Where frankly, 3 out of the 4 people in that deposition didn't come to a conclusion that he had to be taken out of that meeting. Only one person did, and that was Sue Ellen. And she did it unilaterally, and she did it without a step-down, ratcheting down process that we assert should have taken place, especially when you're dealing with a highly protected right, that being the right to free speech during public discourse. So with that in mind, Your Honor, naturally we're here to entertain any questions. This is the opportunity that we have, but you have before you pretty much undisputed evidence in the court, in the video itself and in the depositions to aid you in this particular situation. I might want to add...
If the court dismisses it, does that open a floodgate for people to utilize a forum to speak as they please, as long as it's on point?
No.
It's just the procedure that you're, in terms of the sequence of events, that you find problematic in regards to the quieting of Mr. Baer's speech.
Yeah, I mean, this happens all the time. This happens, we see it on television at night during the candidates are speaking and somebody barks something out in the middle of their candidate's speech, whatever it is. They don't get arrested and thrown out. In fact, there's interesting banter that goes on between the candidate and the individual in the crowd. It's not an automatic arrest situation. In fact, the public becomes even better educated in many of these exchanges and understands what the position is even better because of that kind of discourse, that back and forth. This is back and forth. That's what this is about. The only response that they call disruptive in this particular situation had to do with Mr. Baer responding to a comment made by Mr. Wernick during the course of that video. And you know, this is where people are supposed to be exchanging ideas. Now, if he was supposed to wait in line and raise his hand and, you know, petition for 2 more minutes or something, I don't know what he was supposed to do, but he did. We agree.
Yeah.
But that's just the way these things go. This is common. This is not uncommon. The floodgates that we are worried about are the opposite floodgates. That somebody can arbitrarily have a citizen in a public meeting arrested for speaking his or her mind. That's frightening. And you know, I would encourage, and I think the Constitution and, you know, our forefathers encouraged public discourse. And a lot of times there's going to be contentious things going on during the course of these things, and that's the nature of the beast in the United States of America. That's the way we are.
Right.
And especially in New Hampshire. I mean, it's got the history of town meeting, and that's what you do.
Right.
But it didn't get to the point where we're talking, you know, we're talking about cases in Chicago. We're talking about cases, you know, I mean, I was at the secret things. We defended those guys back in the 70s. That's a whole different thing. I mean, you know, there was a purpose to those protests that would go well beyond that of what Mr. Baer was.
Right, I agree.
Right.
Yeah.
This is mild. And the frightening thing about this case, it may be the direction that you want to give, is that one, Sue Ellen herself says she wasn't really trained in dealing with this sort of thing. Okay? And maybe this is a nice little training tool, but you just don't go out and hook somebody and then handcuff them because they're expressing opinions about what the meeting's about. There has to be a necessary point where reasonable people are going to have to calm things down. Now, they could have moved Mr. Baer out of the meeting. They could have said, you got to knock it off or you can't come back in. If he doesn't knock it off, there's your disorderly. I mean, there's nothing to it at that point, all right? That's not what was going on there. It was just boom, a decision was made, handcuffs were applied, he was arrested. And that's a troubling aspect. But I mean, again, we can respond to anything that Barry wants to say. So.
All right, thank you.
Crop TV.